you all at this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning. Today is Tuesday, the 9th of November, 2021. It's now 2 o'clock. And this is a virtual meeting via MS Teams of this Standing Committee. And we have on the agenda our further deliberations on the Western Cape Biodiversity Bill, Bill B2 of 2021. And as you will recall, we've met earlier in September on this bill as well. Then we went into a constituency period. And during the constituency period, the officials have been preparing their responses to certain of the issues that we've raised at our last meeting. This is still, and if I can call it informal stage, in consideration of the bill. We will be discussing various clauses of the bill, but agreement to those clauses today doesn't necessarily mean that members cannot take it back to their respective caucuses and for further discussion there. And obviously we as a committee will then also formally take a decision on a clause-by-clause basis as well as on the complete bill once we are ready to do that. I want to really thank those officials that joined us here today. Thank you very much, Ms. Niekerk, who did a tremendous amount of work behind the scenes to bring everybody together, to deal with some questions, also questions by myself via her office to our legal advisors, etc. And I really appreciate your support in that regard. Just for the record, again, this meeting is being broadcast and will be available later on YouTube. Also, please mute your mic and use the raise hand function where possible. If you don't have that function on your device, please switch on your video and just indicate by wave of your hand if you want to take part in this meeting. And with that, I first want to give to an opportunity to the honourable members who joined me here today to just introduce themselves for the record as well. Over to you, honourable members.
Deirdre Bartman, member of the committee.
Matlodi Maseko, member of the committee.
Thank you very much, colleagues, for joining me. And I must submit the apology of Honourable Pat Maran, who sent a message on to our procedural officer to submit his apology for today's meeting. Then, Ms. Niekerk, I don't think you've received any other apologies, have you?
There has been no other apologies received, Chairperson.
Thank you very much. And then we are joined here today by the Department of Environmental Affairs and Development Planning. I see the HOD is on as well. Mr. Van Zyl, would you like to introduce yourself and perhaps one or more of your colleagues, or if you would like them to rather introduce themselves, please indicate so.
Chairperson and members, good afternoon, and I'm very happy to be able to link into today's session, having missed the last one due to a clash of other commitments. But certainly I've been kept informed of the process, particularly the engagements and the deliberations by our core team members, Marlene Leroy and Coral Burrs from Cape Nature, and the other colleagues, and of course also Lionel van der Schyff. So for us, and certainly for me personally, getting to this point is a very important step in this journey, and we certainly look forward to travelling it with you through the parliamentary process moving forward. So the other members, we have Karen Shippey and Marlene Leroy from the department, and then Coral Burrs and Barry Barnes from Cape Nature that have come into the engagement this afternoon. Thank you, Chair.
Thank you very much. And perhaps Mr. van der Schyff would like to introduce him as well. himself.
Hi, good afternoon. Lionel van der Skerp, Department of the Premier Legal Services.
Good, thank you very much. And then I believe I've seen another name here. Is it Njamela? Mr. Njamela, would you like to introduce yourself as well?
Good afternoon, all protocol observers. I'm Loiso Njamela from Salga, Western Cape, responsible for intergovernmental relations. Thanks very much.
Good, thank you very much for joining us. You're most welcome, sir. And then from the Provincial Parliament side, perhaps if those officials could also introduce themselves, starting with Advocate Marstorp.
Thank you, Chairperson. Good afternoon, and good afternoon to the colleagues on the platform. My name is Romeo Marstorp, Legal Advisor for the Provincial Parliament. Thank you.
Good, thank you. And I think I've already mentioned the presence and support and hard work behind the scenes of Ms. Shireen Niekerk. Thank you, Honourable Herren. I think you've also just joined us. I see there's a little yellow spot next to your picture. I don't know what that means, but you're most welcome. Please introduce yourself.
James, I can't be load shedding, so I've been struggling for the last 10 minutes to connect. I may not last.
Honourable Herren, thank you very much. I did recognize your voice, but I couldn't follow what you were saying, except that the word load shedding.
Yeah.
Okay, good. I hope you can follow us. We're struggling to hear you. There seems to be some flat batteries somewhere, and I trust it's the devices that you're trying to use. Then also we have, I see online, Mr. Johan Vermeulen, our Senior Procedural Officer. And if I go through the list, Ms. Nomfundo Mshumpelu, who's also supporting us as a committee assistant, and Mr. Shiraz Assam from IT. Thank you very much for being here. Without further ado, honourable members, just a little bit of background. This bill, the Western Cape Biodiversity Bill, B2 of 2021, was referred to this committee exactly, I think, 5 months ago on the 9th of June this year. And we then first received a briefing from the Department of Environmental Affairs and Development Planning on the 15th of June. And then the bill was advertised in the print media, on social media, and also letters were sent to specific stakeholders, including municipalities. And the closing date for those comments was the 10th of August. By the 10th of August, we received comments from 12 people and entities: BirdLife South Africa, the City of Cape Town, Department of Community Safety, Department of Transport and Public Works, an individual, Mr. Louis Steenkamp, and as well as Mr. Guy Thiessen, the National Department of Forestry, Fisheries and Environment sent through a draft comment at that stage. Then also SANBI, the National Biodiversity Institute, also from Ms. T. Netononda, the Western Cape Biosphere Reserves, the Department of Agriculture and Wildlife Ranching South Africa. And quite interesting is that we received a further 7 comments after the closing date, while actually, you know, we allowed for almost a month, well, almost 2 months for comments, and we've actually been able to also accommodate the late comments from Wildlife Animal Protection Forum of South Africa, Agri Western Cape, Cox Attorneys, Drakensberg Municipality, Salga, the Whale Coast Conservation, and also again the Wildlife Ranchers Forum. So all these comments were then forwarded to the Department of Environmental Affairs and Development Planning for their comment, and we were then served with a matrix of comments, which was then forwarded to all the committee members, And then we met on the 31st of August, and as I've said, the last meeting was on the 14th of September 2021 to consider the stakeholder input and the department's responses thereto in terms of this matrix. And then at the meeting of the 14th of September, a few concerns were raised in relation to aspects such as the definition of well-being, clause 16, which deals with the appointment of the chairperson of the board and the board's ability to function should the chairperson be absent or no chairperson appointed. Then there was also clause 63, the routine inspections, where Advocate Master pointed out to us that, you know, this bill is actually giving some serious powers to inspectors. And then clause 71, the administrative penalties were also raised as an aspect that needed further attention. Now, my understanding is that the department has noted these concerns and that the department will today start this meeting by expanding upon the response that the department has sent through to us. And having said that, and if all the members are happy for us to proceed, I will now give the department an opportunity to respond to the concerns raised in the, I say concerns, some were just comments raised in the meeting of the 14th of September 2021. And I presume it might be Ms. LaRosse that might be leading us into this part of the meeting. Ms. LaRosse, over to you then.
Good afternoon, Chair and honourable members. Just turning my camera on to greet you, and I will immediately move to the matrix that has been circulated and move systematically through that matrix.
Thank you. We're still waiting for your screen to appear on ours. Ah, there it is. Thank you.
Thank you, sir. So I will move through the individual comments that were made at the meeting previously held with the Standing Committee. And we have taken the comments into the matrix format so that we can deal with them systematically. The first comment was under definitions. As chairperson, you have already indicated. There was the definition of well-being, that well-being is not limited to animals, and that as the term is used in other contexts, and that the proposal was to consider inserting a qualification into the definition so that the reference is made to animals unless the context indicates otherwise. Chairperson, we were in the review of that actual section within the bill, we noted that at the beginning of clause 1 of the bill, in terms of the definition section, we have the phrase "in this act unless the context indicates otherwise." And hence, we believe the insertion of "unless the context indicates otherwise" is in fact dealt with. However, to address the Standing Committee's comment regarding the referral to animals, we propose to amend the definition as follows. So the definition then will read, or it is proposed to read, well-being means the state of ecological, behavioral, physical, and psychological health of a wild animal. So we believe that takes on board then the two matters or the two aspects that were raised, and we believe that the new definition or the proposed recommended definition is clearer and is helpful within that context. The second issue raised was around clause 16, specifically in clause 16.3b, that it appeared that the vice chairperson's position is limited in that only the chairperson can call for a meeting of the board if the majority of the members request him or her to call such a meeting. In relation to the board remaining functional, the concern was that the bill is unclear as to who will be mandated to call the meeting if the chairperson resigns and there is a vacancy of the chairperson. The proposal is to consider inserting an additional clause to read as follows. The Vice Chairperson will act as Chairperson in the absence of the Chairperson or when requested by the Chairperson to do so, or do so if the Chairperson is unable to fulfill his or her duties. In that specific response, and I'll deal with these two pieces separately under clause 16. To deal with the first matter, the Vice Chairperson and an acting Chairperson are appointed specifically to deal with the void that may be created by the Chairperson's absence. And then they are thus conferred with the full powers of the Chair, which means that they can call a meeting. However, given the Board's comment and the potential need for clarity in this regard, we recommend that we insert an additional clause, subclause 4, to read as follows. If the Chairperson is for any reason unable to perform his or her functions, the Vice Chairperson, and failing him or her, the acting Chairperson, must perform the functions of the Chairperson. And then that would deal with not just calling meetings, but any other matters that need to be dealt with in the absence of a Chairperson as appointed normally. Chairperson, I'm going to move to the second component under clause 16, and this was the request to consider the proposal that to allow the Chief Executive Officer, or to add in a clause to enable the Chief Executive Officer to call board meetings in the case where there is no Chairperson or Vice Chairperson. And the suggestion there was to include the clause, if there is no Chairperson, Vice Chairperson, or acting Chairperson for a period of 4 weeks, the CEO may call a board meeting. In terms of the response that has been considered by the team, the following is the response. In terms of section 12.2e, it provides for developing a board charter which can enable procedural issues to be addressed. As the Minister is the executive authority responsible for board appointments and the effective functioning of the board, the CEO or head of department can intercede with the Minister to ensure timely appointment of an acting Chairperson. Further, it is desirable to maintain a separation of powers between executive and non-executive board functions, and hence the drafting team does not recommend this insertion. To move on, Chairperson, then to clause 63, routine inspections. If the only intention of the clause 63.1 is to inspect, then the current wording of the clause raises concerns with regard to infringement of rights in a routine inspection. In this regard, the bill appears to be silent on the consequences and remedies for any abuse of power or infringement by nature conservation officers or rangers or other enforcement officials in terms of the rights granted under this clause, and that the proposal of the Western Cape legal advisor has advised that we could amend as follows, and we've taken this proposed amendment on board to deal with the matter of consequences for any abuse of power. The drafting committee and department would like to respond as follows: that any infringement or abuse of powers by nature conservation officers or rangers will be dealt with in terms of their employment contract and human resource management policies, which directly deal with misconduct of officials. Further, in terms of the clause 56C, the CEO may at any time withdraw designation contemplated in paragraph A, and summarily that appointment as an enforcement official can be terminated. We believe that that is sufficient recourse and remedy for any potential abuse in that context. And then, Chairperson, to move to the amendment which was proposed by the advisor to yourselves, Advocate Marsdorp. We recommend thus the following: that the wording be amended to read as follows. 63.1, a nature conservation officer, subject to section 58, may at any reasonable time conduct a routine inspection, and without a warrant enter and inspect any premises or inspect any bag, box or other item for the purposes of ascertaining compliance with A, the legislation for which that nature conservation officer was designated in terms of section 58, or B, this act and a term or condition of an authorization issued in terms of this act. So with a very small change, I think it's addressed that concern directly, and the drafting team is very comfortable with that particular change as well. Then moving on to administrative penalties under clause 71, that the clause does not make provision for admission of guilt or spot fines and reviewing penalties on a regular basis. And then the proposal from the committee was to consider inserting these provisions into the bill. Okay, then if I can move over onto the responses, that all fines and penalties are dealt with in section 73 of the bill, and that it's important to note that administrative penalties are separate from normal fines payable on admission of guilt. Admission of guilt fine is a fine thus paid without any appearance in court. The drafting team and the department feel that admission of guilt fines are dealt with comprehensively under section 57 and 57A of the Criminal Procedures Act, and in terms of the approved fines list, also in terms of 57.5A of the CPA, and these are regularly updated. The last update, in fact, was 2016. The fine amounts are not determined by Cape Nature, but by a magistrate's committee on admission of guilt fines. And then for the purposes of completeness, we believe that an additional clause can be added to address the committee's concerns here. And the proposal is as follows, that within clause 73, the following subclause is inserted. Subclause 4 to read as follows, that the provisions of sections 56, 57, and 57A of the Criminal Procedure Act 1977 apply subject to such modifications as the context may require to written notices, penalties, and fines referred to in this section, and thereby addressing the issues in relation to the issues of fines, which are actually under section 73 of the current draft bill. Chairperson, that deals with the matters which were raised by the committee. I hand back to you, sir.
Thank you very much, honourable members. Are there any of you that would like to comment first just on what has just been shared with the committee? If not, can I just ask, in terms of clause 63.1, the routine inspections one, Advocate Marstorp alerted us to this last time, and I'm for one or other reason concerned that that clause may be abused for purposes other than just the execution of duties. And I see there it says for the purposes of ascertaining compliance with the legislation. So are you happy that any nature conservation officer that would be asking somebody, you know, or that would be entering or inspecting any premises or examine any bag or box for purposes other than just in the execution of his or her duties, that such a person would be guilty of acting outside of the law? So I'm just concerned where people have got other motives and then want to abuse their powers. And perhaps I must put this to Advocate Marstorp. Advocate, are you happy that the current word or the proposed wording then for section 63 would really be strict enough or narrow enough so that should somebody choose to abuse that right, that person would be guilty of an offence.
Chairperson, in fact, the wording as it was before this proposed amendment was somewhat open to abuse and to, if you like, it had quite a bit of a liberal options, if you like. As it stands now, textually, it is much more restrictive and indeed limits the activity of an officer to inspection and everything that follows to give effect to that inspection. So on the text, even in the context of the whole section there, I'm satisfied that it serves its intended purpose.
Good, thank you. Thank you for that assurance. Can I also then ask honourable members in terms of the other proposed amendments that the department has now put in front of us? For the time being, you've got no further questions on that, and there seems to be, as I've said, an informal acceptance of that at this stage. In the absence of any hands, I take that as a yes. Good, thank you very much. Now, Ms. Nikak, I think the next thing that we should do is then to again look at the input that we've received by the various stakeholders on the various clauses, starting and going through the bill from the start of the bill, from the first page, and then just consider again the stakeholders' comments. I don't think we as a committee has considered them. I do know that they were given through or passed on to the department, who then, made its own decision on whether they believe some of those comments should be incorporated, or if some of those comments are not necessary, etc. So my proposal would be then that we now go through the comments received, and thank you for that. We've got a matrix, and that we just consider them, and so that we can afterwards say to the public, we have considered your comments, we've considered your input that you've made, and I think a lot of people have really taken to a lot of trouble to do this for us, and we seriously considered that. Ms. Nikak, would that be would you recommend it next step?
Yes, Chairperson, that is correct. I will recommend that, because although in the matrix document, the submissions received, the department has already responded to it and has taken the committee through their response. However, the committee has not yet reached an informal agreement as to whether they accept it or not. So I think that would be absolutely correct, that we go through every single submission and then get the committee's agreement or non-agreement on the department's comment on that submission. Ms. LaRosse will flag the matrix if that will help in any way, Chairperson.
That was going to be my next question. Can we get something on the screen so that we just keep track of our progress in this regard? Thank you very much, Ms. LaRosse, for that. So again, members, you must say whether you want me to take us through the various items. I think let's start then with item number 1. That was an input from the City of Cape Town, where they comment that environmental legislation, and they felt that it's missing the national subordinate legislation. And the department responded to that. Have we got that now with us, clause 1? Okay, and the The department's response was that the definition of environmental legislation would include all regulations made thereunder, and therefore a detailed listing of each set of regulations is not deemed necessary. However, the wording "and includes any regulations or other subordinate legislation made in terms of these acts" should be or could be considered for inclusion. Correct? Ms. LaRosse? So it seems to me, as a department, you said you would be happy for us to amend clause 1 and to add "and includes any regulations or other subordinate legislation made in terms of these acts."
Yes, sir. I'm sorry, I was just trying to find the place on the matrix that you were referring to.
Okay, good. I think it would be on page 8 after line 49 in terms of the bill. I don't know on your matrix where you would find that then. Okay, good. Then that deals with the first input by the City of Cape Town. Then we also have there was a request that export be defined and that we actually include an attempt to export. Okay. And if I'm correct, you said the definition for export could be amended. I mean, so that export means the transfer or attempted transfer of any species or specimen or any part or derivative of such species or specimen from any position or place in the province to another province or the republic of the republic, or to a country outside the borders of the republic. Okay, so you seem to be happy if we consider amending export to also include attempted transfer. Yes,
sir, we would recommend so. Thank you.
Good, thank you. And honourable members, please raise your hands if you have a different view on any of this. Okay. Then Agri Western Cape also on clause 1 in terms of the environmental legislation, that the definition omits NEMA as well as the Conservation of Agricultural Resources Act, and the department responded by saying yes, this is an omission, that NEMA, National Environmental Management Act, Act 107 of 1998, should be included in the definition of environmental legislation. Again, with no, I take silence as a sign of people supporting this. Good, Ms. LaRosse, still happy for us to?
Yes, thank you, sir.
Insert that amendment. Good. Then also City of Cape Town, they believe that there should have been a definition for spatial development framework, and it seems to me you are happy as a department with their proposal, and that you would like to add a definition. Spatial development framework means a spatial development framework as contemplated in the SPLUMA, Spatial Planning and Land Use Management Act, Act 16 of 2013. Okay, so that is also another proposed amendment to the bill as originally submitted to us. Again, I take silence as concurrence. Then there was, sorry, Honourable Bartman, please proceed.
It's just that the matrix disappeared. I just wanted to see, but okay. I agree.
I think it's back now. I think it's back now. That it said they add the definition spatial development framework means a spatial development framework as contemplated in the Spatial Planning and Land Use Management Act. Okay, good. Again, then there was also an input regarding, or some debate regarding the whole well-being, and I think you've just referred to that as well, where it was felt that well-being being means the holistic circumstances and conditions of an animal, and it seems to me well-being, the amendment that the department would support, recommend replacing definition of well-being means a state where the living conditions of a faunal biological resource are conducive to its health, and that be replaced with well-being as it relates to animals means the state of ecological, behavioral, physical and physiological health of an animal. Sorry, again, the matrix is, oh, there it is back. Okay. Would you like to comment on that, Ms. LaRosse?
I just wanted to comment, sir, that in terms of the discussion we had at the standing committee meeting on the 14th of September, the discussions that we've had subsequent to that have now superseded that original response with what is being projected in the standing committee's issues raised on the 14th of September. So indeed, the proposed amendment to that definition is, as we discussed just beforehand, which is well-being means the state of ecological, behavioral, physical and psychological health of a wild animal. Thank you.
Ms. LaRosse, may I ask why a wild animal? Shouldn't it refer to more than just, couldn't domestic animals also be, or domesticated animals also be included under that definition?
So that would unfortunately push the scope into, for example, agricultural space and into an area of welfare which is not currently the responsibility of the executive authority in terms of the biodiversity legislation. So we need to stay within the biodiversity scope, and hence we have wild animal, which is also defined. Thank you.
Accepted. Thank you for that clarification. Okay, good. So there you have it, members. Again, if you're happy, we're going to proceed. The next one by Cox Attorneys on clause 5 with the heading duty of the state. The stakeholder comment came down to, it's thus notable that the draft bill fails to acknowledge the nature of the environmental right and indeed the importance of the NEMA principles in the lawmaking process. And that is where clause 5, the department is happy to have that amended by adding and apply the environmental management principles in section 2 of the National Environmental Management Act. Sorry, I think you need to jump around a lot, Ms. LaRosse, and my apologies for that. Cox Attorneys, I don't know if it would help if you search for that.
Chairperson?
Yes, Ms.
I just want to point out to you that you're not working from the matrix document at the moment, I don't think, because we're missing out quite a few of the submissions received from other stakeholders that were not necessarily supported by the department.
Okay, so I
think that's why we're jumping around like this now, because we're not going through the document.
Okay, my apologies, and thank you for pointing that out to me. Comments matrix, I've got it here in front of me. So can I just quickly say we've dealt with item number 1. Item 2, a lot of that is just where we just noted the comments, you know, where people say they support the bill. Item 3 is also not a proposed amendment. I think we can go down in the matrix document. Members, I hope you've got them open in front of you as well. So item number 4, again, Drakensberg municipality being in support bird life. It's more of a comment. Are you happy, Ms. Niekerk, if we go through this document? Item 6.
Yes, Chairperson.
The Wild Coast Conservation. Okay, so again, they proposed the definition and appointment of an advisory committees and also regulation of wildlife sanctuaries, game farms and similar commercial activities. Okay, and the department's response was that detailed comments are addressed below on these matters. And then Mr. Guy Thiessen, that is item number 7. He suggested that the marine protected areas be increased. Now, the comment there was just that this is the domain of the national government, and then a complete ban of all blood sport, of competitive fishing of wild fish. Now again, fishing, I think quite rightly as stated here, is a responsibility or a mandate under the national government. Then Mr. Cox, item number 8. My principal concern is that this bill will be unlawful and that it's unworkable, and as such adds to the growing pile of unworkable biodiversity laws. Now, the comment by the department on this one is we have got the legislative mandate to provide a legal framework for nature conservation and the protection. So that comment has not been supported. The same Mr. Cox, as I've just said, does indeed point out that the environmental management principles should be referred to in this biodiversity bill, and that one we've dealt with already. That one has then been taken up, and there seems to be support for an insertion or amendment to clause 5. Good. Then Mr. Cox also refers to invasive species, etc., which is not really dealt with in this bill at this point, where invasive species are identified, etc. Okay. Then if we go on to item number 9, Mr. Errol Finkelstein of the Western Cape Biosphere Reserves, again, he gives credit for the fact that this legislation seems to simplify and combine prior legislation, which I think we're all grateful for. Then item number 10, wildlife ranching general. They strongly advise Cape Nature to align itself with the National Department of Forestry, Fisheries and Environment. And the comment is that, you know, we note this, and the bill is framework legislation, and it is aligned with the national legislation and policy. Good. So that is being dealt with. Item number 11, the Game Ranchers Forum. Again, their comment was more about the process of commenting, and again they refer to NEMA. So I think that is being dealt with. Again, if we say that this bill is framework legislation and it is aligned with the national legislation and policy. Which brings us to item number 12, also by the Game Ranchers Forum, which made a general comment in terms of the public participation, and they believe that there were not enough consultation in the development of the Western Cape Biodiversity Bill. And we've got the response there that, various drafts of this bill was published, produced, and also liaised with, and it was published in 2015, 2019, etc. So I think we don't quite understand why they said that there's not been enough opportunity to comment on this bill. Then also wildlife ranching, again, in terms of the public participation, as I've already said, this bill has been published, and the Provincial Cabinet resolved that a RIA, Regulatory Impact Assessment, must be undertaken. However, a first draft of the bill was produced in 2015, which predates the implementation of RIAs, and it was therefore not possible to conduct a RIA on the bill at that stage. Good. Honourable members, you will have to draw my attention because I'm now reading from my screen in terms of the matrix. Item number 14, again, the Game Ranchers Forum, a general comment where they fear that there may be some conflict between the Western Cape Bill and the National Biodiversity Policy and Act. Now, again, we are entitled to, and we have the legislative mandate to pass biodiversity and ecosystem legislation in the province. Obviously, if there is a conflict with the national and provincial, between national and provincial, obviously then, it will be addressed. But the comment is that this is framework legislation, and it enables specific regulations that can be adjusted to align with the national policy frameworks, etc. Okay, that is then the one they marked in the red that Ms. LaRosse beamed earlier. In terms of item number 16, again, the Game Ranchers Forum, they were concerned that the impact and contribution of the National Development Plan was not taken into account, and that they believe the Director General were issued regulations on policies on the conservation and use of elephant, lion, leopard, and rhinoceros, etc. That position should also be taken into account. Now, again, the RIA, the decision on RIA only came after this bill was first published, and perhaps I could just ask Ms. LaRosse, in terms of the regulatory impact assessment, which was also raised by Agri Western Cape. I know RIAs have got their role and their place, and quite often we've seen legislation in South Africa passed without taking into account the impact that it might have. Perhaps if you would just like to expand on what you believe the impact may be of this biodiversity bill, should this be enacted. Ms. LaRosse, do you foresee that there might be an unforeseen impact by this bill?
Chairperson, what I think that the approach that we've had to take, given the Cabinet instruction, is to proceed with that instruction. However, in terms of a RIA and how one would approach the application in a RIA is effectively asking the question, well, do you or do you not actually need to provide for law or regulations in this space? So from the get-go, we are moving from old order legislation into new legislation. And the principle has always been rationalization. In other words, to move into a framework statute that can easily and be more flexible, and also deal with less minutiae within the actual statute itself. And so hence what you will be seeing is a rationalization in terms of the regulatory approach and the institutions adapting towards that. So ultimately, our view in terms of the impact of the bill is that it provides the different sectors, would you call, and for the regulated community, firstly, a modernized and rationalized approach, and secondly, the regulated community is now brought into a space where there's more coherence between national and provincial legislation in terms of how they articulate. Indeed, it should reduce the amount of red tape to which the regulated community must respond. And I believe that we've done as much as we can to try and step up and step back in terms of that particular space. Chairperson, in terms of the requirement in relation to the national constitutional principles as well as the Western Cape Constitution, we are making sure that Western Cape biodiversity assets and resources are within the best available approaches and within our budgetary envelope. We are taking the most efficient approach to carrying forward this legal mandate in a rationalized format. So yes, there will be sectors that are affected, and they are going to be affected in a more rational way, is what I believe is on the table. So if we didn't go through this process of modernization, we would still be stuck in the same situation as we are today, which I believe many regulated stakeholders are saying it needs to change. And hence we're responding to that, the existing impact of the legislation and regulations. I hope that provides sufficient answer to you, Chairperson, but also to note that we have a really significant international responsibility in the Western Cape. We are responsible for most of a floral kingdom in the Western Cape, and we do need to strengthen our efforts and frameworks to enable proactive mechanisms for protection. And I believe that has really been the emphasis of where we're moving, to give the regulated community a good understanding of the policy and regulatory intentions. So all in all, I believe our regulated community in all sectors are actually better protected in this particular space because it leans more on the proactive forward planning for biodiversity, spatial plans, for example, better integration into spatial development frameworks, and a better articulation between biodiversity legislation and planning legislation, really moving in that direction. And hence moving from a reactive approach to a more proactive approach, we believe to be more efficient and to enable the regulated community to work as partners in that space. Having said that, there will always be resistance to improve protection where interests are held which need to comply with such increased protection. And I think we shouldn't be naive about that either. But sir, I believe, I hope I've answered your question. Thank you.
Thank you very much for that response. Indeed, you have. If I can continue, in item number 18, we've got again the Wildlife Ranching of South Africa expressing its willingness to work with Cape Nature and the Western Cape in the development of a wildlife economy. And obviously that will come down to regulations, which I believe is provided for in this legislation, but obviously this bill is not going to go into the detail, or as you've said, the minute in terms of regulations, etc. So the opportunity might still be there for them to take part in that. Then Mr. Louis Steenkamp, who initially also asked to address us as a committee, and later on indicated that due to connection complications, he might not be able to do this. He raised a number of issues, one being the visual pollution, then also the issue of waste management, and the last one is the cost of conservation to private landowners. And in terms of the visual pollution, I think the comment was that biodiversity bill is not the right place to address visual impact of or visual pollution. The second one is that, there is a waste management plan, and that litter management should rather be dealt with under the waste management plan. And we've got such an integrated one for the Western Cape as a province. The third one that he raises is a very interesting one, in which he says that, for private landowners, we do want private landowners also to assist with conservation efforts and to also assist with the biodiversity of the province, but that it brings about a certain cost for landowners, particularly the one that he's referring to is agriculture or farming. And he at one stage seems to also have been acting against poachers, and he had a dilemma that, once some succulents have been removed, etc., they need to be cared for and put back. And this obviously, unless you will see them go to waste, that obviously has some cost implications as well. But I don't know, honourable members, we know what the financial position is, and we also know that, owning assets often bring about expenses, be it a vehicle, be it a historic house, be it a thatched building. Yes, I think if we can support people with conservation efforts, we must do so. And Ms. LaRoche, you mentioned there in the department's comments the possibility of even rebates on certain conservation efforts. Perhaps if you would just like to fill us in on that one, the rebates, etc., would that be for private nature reserves or for conservation areas? What do you envisage in that regard?
Correct, sir. There are two current areas where landowners that are participating in formally conserved areas can benefit. The first is in terms of the Property Rates Act and the relevant policy of a local government that can enable certain rates reductions for conservation, formally conserved areas. That is the first area. So it's rates, municipal rates. The second area is already an area that has been piloted in terms of income tax, which is a second area within which landowners that are in a formal conservation agreement or within a formal protected area status can also claim back such from their formal taxes. So those are existing mechanisms that support and are incentives towards stewardship. Having said that, Chairperson, there are also obviously various extension approaches in terms of the establishment of those stewardship areas which Cape Nature supports as well in the process, which is actually a massive expense in terms of the transaction costs, the legal processes, etc., that support just the establishment of such areas. I hope I've answered your question. Thank you, sir.
Good. Again, I don't see any hands, so let's proceed. Thank you very much for that. Then your sister department, the Department of Agriculture, suggested that there should be a reference to climatic resilience, or that climate change adaptation should be added in certain clauses. Now, your comment was that these suggestions have been considered to be relevant, but have they led to any inclusions, Ms. LaRose?
Chairperson, I think that we will address them just a little bit further down the matrix, because these were very general requests, and then there were specific wording changes that come just a little bit later.
Okay. Good. Thank you very much for that then. And then also Agri-Western Cape also expressed a concern about the impact on the agricultural sector of some of the wide powers given to the provincial minister in terms of certain sections. And so we must just watch out for the declaration of mountain catchment areas, the management of mountain catchment areas, and ecosystems or ecological infrastructure in need of special protection. But as you've said, that was also a general comment. They didn't propose any specific amendments at this stage, so we'll keep that in mind when we get to those positions. Then the Whale Coast Conservation wanted us to also consider the commercial exploitation of wild animals confined to small encampments, and they believe that this kind of wildlife usage should be regulated. And I think what we've seen is that, yes, there have been a growing number of regulations for the breeding of lion, the treatment of elephants, and so on. Again, the general comment from the Wildlife Animal Protection Forum of South Africa, where they've made a number of general comments, and I think what you've said is that you know, there have been court cases where, for example, in terms of the bones of lions, etc., that some of these court cases already indicated that there is some protection for wild animals, and particularly this new thing where people want to breed animals for their skins, etc. So in general, that general comment, it seems to me, has been addressed as well. Then item 24, and please interrupt me if you feel necessary, is the Wildlife Animal Protection Forum, and they are concerned that the current legal frameworks are not succeeding in slowing down the rapid biodiversity decline. And I think what we can say is we note this legislation is exactly to assist and to try and see if that decline can be addressed. Okay. Then the next one is item number 25 on page 14. Again, they say they're concerned about the continuation of exploitative language. Now, the comment was that the language in this bill was aligned to national and provincial legislation for uniformity. So I think we cannot change the national wording used in generally. And that brings us then to the next item, which is item number 26. Again, Agri-Western Cape, a general remark from them, where they again refer to NEMBA and NEMPA as offshoots of NEMA and the Constitution. And again, they have proposed conservation committees. And I don't know, you've just said that you noted this whole thing of conservation committees. Is there a parallel structure for that in this bill, or how should we deal with their comment?
So the matters are dealt with in more detail below, but they're kind of incrementally expanded within the comment. So this is still a general comment. Indeed, the request to have a representative body to advise the provincial minister, we believe that is already catered for by the functions in the domain of the Board of Cape Nature. And as such, additional advisory bodies would derogate that role and legal mandate of the board. We wouldn't want to create such a parallel structure. But there's a more detailed set of proposals made further down in the comments once we get to the detailed sections in terms of additional structures proposed by the commentator. Chairperson, I wonder if I could just also comment on the previous set of comments in relation to the Wildlife Protection Association's comments in terms of the changes that one would have seen more recently in relation to matters that you have just recently dealt with. The revision of policies in relation to certain species of wild animal, how they are dealt with, how they are addressed within policy, and how that is going to is already heralding in a sea change in how we have an articulation between conservation and welfare issues. And what we're trying to do within this framework legislation is to anticipate such changes. And indeed, our conversations within this committee and outside of this committee in relation to the definitions of welfare and how that needs to be considered in the context of any decisions you make about biodiversity really is providing for that articulation. So many of the comments, or a lot of the comments that have been made in relation to the need for the sea change, well, that sea change is already happening, and we will be obviously aligning our approaches in terms of regulation with those changes as they are worked on by national government, noting that the new or changed draft white paper will be probably a few years in the making. We're not sure, and we know it is being expedited, but that sea change that we're looking for is indeed being carried forward within the national legislation. And as we've explained before, this framework legislation is designed to easily be able to articulate with that, with the spotlight also being on how we approach issues of welfare in that regard. Thanks, Chairperson.
Good, thank you very much. I think that brings us also, and again, it's part of the general comments by Agri Western Cape, in terms of what they call the farming river interface in the Western Cape, and again, the indication was that some of these issues are addressed in the detailed comments going forward. So let's let that stand over for the time being. Then now we're coming to more specific sections of the bill. The Wildlife Animal Protection Forum of South Africa has got some comment regarding the long title of the bill, and they want the word ecologically sustainable use of biodiversity, but you say it's more than just the sustainable use, and the bill uses the term sustainable use of biodiversity and ecosystems. So hopefully that is covered again, honourable members must respond to that if they want to. Then in terms of the Wildlife Animal Protection Forum of South Africa, their comment on the preamble to the bill, again, they are particularly concerned about the management of baboons in the Western Cape and particularly in the peninsula. And I'm grateful to see that they also say that it's a very complex question with many role players. So I think the management of a specific species, such as baboons, is then provided for in the bill, and you say we will see it under clause 49.4, and obviously will be dealt with in terms of regulations. And I think, if I may propose, that we don't in the bill start going into detail for different species of animals and the unique challenges of managing each of those species. Which brings us then also in terms of the preamble to this, it's item 31, or comment number 31, received from parties that wish to comment, and there they make sure that the long term should be included. They say that if present and future generations must benefit, we offer the view that adverse impact should be avoided, not only long term but also short term. So I think what we're saying is that the long term benefits or the long term vision could sometimes have short term adverse impacts, but obviously for the long term benefit, short term impacts should be avoided. So hopefully that is sufficiently covered in terms of what we have in front of us. Then also, and sorry, my screen just jumped. The next one that I have here is number 32 from the City of Cape Town. Again, where they are concerned with the interface between the biodiversity bill and the spatial development frameworks, with biodiversity layovers, and it's an interesting development at municipal level with their spatial planning and land use plans that they have. Now, on this one, that is where we are now going to consider, I believe, to insert in the definition of environmental legislation the clause and includes any regulations or other subordinate legislation made in terms of these acts. This is then where the Spatial Planning and Land Use Management Act comes in as well. Good. Brings us to comment number 33, the request from the Wildlife Animal Protection Forum that aquatic resources should also be included, also the oceans, and water resources here is, in terms of the bill, referred to under the National Water Act definition, and the bill does not use the term aquatic resources. Is there a reason why, Mr. LaRosse, that proposal has been not taken on board?
Yes, sir. We are trying to make sure that insofar as possible, our definitions align to definitions in other statutes. So in this particular instance, we have used the term water resources, and water resources are such a definition that occurs within the National Water Act. And so hence the term, rather than aquatic resources, we use the term water resources instead to align with other national statutes.
Good, thank you. And then input 34 by the National Biodiversity Institute, SANBI. They wanted to propose an amendment to the definition of ecosystem services, whereas we've got means the benefits humans derive from. They want to change that means the contributions that natural or semi-natural ecosystems make to human well-being. And again, it seems to me, Ms. LaRosse, you do not support this proposed change in the definition. Is it again because the definition of ecosystem services is taken up in other legislation?
Thank you, Chairperson. The reasons for not wanting to exclude subclause C from the definition, which speaks to supporting services such as nutrient cycling, soil formation and crop pollination, is that these are aspects of ecosystem services which are well acknowledged as part of broader ecosystem services. And we believe that the areas, for example, within modified landscapes also produce ecosystem services, and we need to discourage further degradation thereof. We believe them to be significant contributors to ecosystem services in terms of those soil processes and water resources. And just as an example, conservation agriculture within the Western Cape, which is, I believe, leading the pack in South Africa, has already shown how significant advances and improvements to ecosystem services can be rendered from those approaches in agriculture. So a more landscape approach. Also, just in terms of why we wouldn't want to take on board the specific changes, is that we believe the direct link between people and ecosystem services are really important to emphasize. And the more we provide for levels of abstraction, in other words, distance between ourselves and such services, the more difficult it is for people to understand their direct reliance thereon. So that's why we don't support the specific change.
Good. Again, we continue in the absence of anyone jumping in to respond. Then the Wildlife Animal Protection Forum wants a change to the definition of hunt, where the current definition in paragraph D says hunt could mean to shoot at or poison, and they object to the use of poison. But I think what we're saying is that, should hunting be prohibited, obviously it means that shooting and the poisoning of animals should also be prohibited, and that therefore, poisoning of wildlife in order to gather it or to hunt it, that the word poison should remain as it is. Then again, the next one is the definition of the term long term. Now, in terms of our definition, long term means a period of 50 years or longer. And it seems to me they believe long term could also be within 50 years. Long term doesn't mean only to start after 50 years. Ms. LaRosse, would you like to comment on why 50 years and not, say, for example, somewhat shorter terms?
Chairperson, we've taken our lead pretty much from broader frameworks such as these definitions which are used in intergovernmental panels, for example, on climate change, etc. And hence we've sort of pinned our timeframes to similar timeframes therein. And I think that the definition as it's put forward does not exclude shorter term timeframes. But it is actually, the emphasis here is to ensure that the longer term impacts and the longer term issues are actually considered.
Okay, but 50 years, there's no reason why it's not 45 or 55. It's just that it just points to what is generally seen as a longer term then.
Correct, Chair.
Good. Thank you. The next one is again
Chairperson.
Sanby. Yes, Mr. Advocate Marstorp, please come in.
If you don't mind me breaking your momentum, I don't have much of a long-term battery life left on my laptop. We have a power outage here, and I think I've got about 10–15% of battery life left. So it may be that in due course, I will be shut out or disconnected from participation. The power outage should be till 4:30 p.m. And hopefully after that time, I'll be able to reconnect just in case I get disconnected.
Thank you. Thank you. I really do hope that you would be able to stretch that 10% by turning down perhaps screen brightness and everything else that you can do, because your presence is valuable. I almost want to say essential when we're dealing with these clauses, etc. But thank you for alerting me to that. Let's see how fast we can go. Good. The next one is the definition of landowner. The current definition is quite extensive that we have. Means the registered owner of land, except that if the land is not occupied by the registered owner, it means the person who lawfully occupies it, etc., etc. And it seems to me what we're saying is that the department is of the opinion that the definition should be that wide, Sanby actually also supports the fact that it's quite wide, but they want to delete the one where it says that landowner means the registered owner. If it means the person who has any registered real right of occupation in respect of the land subject to any other law should be removed. And it seems to me the department says no, you believe that should remain. Good. Then item 38 by, I think it was Miss T. Netunonda, says that the use of provincial minister will confuse the public when they read other environmental legislation, but the department has said that this leans onto the Constitution of the Western Cape, and we refer to our MECs as provincial ministers. Then item 39 is the Wildlife Animal Protection Forum of South Africa. They have a comment on the word resilience and believe that regenerative practices must be implemented as well. And the department has said yes, but there are many other practices that are also employed, and regenerative practices, we shouldn't restrict it to regenerative practices. Then 40, also Wildlife Animal Forum, the definition of sustainable, and again they want sustainable to mean the use or impact on biodiversity, ecosystems in a way and at a rate. And the department believes that the current definition that we have of sustainable, and I can read it to you, sustainable means the use of or impact on biodiversity, ecosystems in a way and at a rate that will not lead to its long-term decline, and that will not compromise or disrupt its ecological integrity and ensures its continued persistence. So it seems to me as if that definition is covering what I think is intended for it to do. Then also the word well-being, I think we have already dealt with well-being as a term or as a definition. And then Wildlife Animal Protection Forum wanted us to expand the definition list. Now, obviously, you only define the terms that you use in a bill. So obviously we're not going to define terms that might have to do with biodiversity, but that is not used in the remainder of this bill. Which brings me to item 43, the Western Cape Department of Agriculture. Again, they refer to the issues of climate change adaptation, and as the department was of the opinion that the objective 2C is already addressing the issue of climate change adaptation, and that it's not necessary to change the proposed bill to provide for that. Then 44, Wildlife Animal Protection Forum of South Africa, clause 2 in the bill, where the objectives of the bill are spelled out, and they are of the view that B, which says give effect to Section 81M of the Western Cape Constitution to protect and conserve the environment in the province, including its unique biodiversity for the benefit of present and future generations, that contradicts the next paragraph, which says ensure the long-term ecological sustainability and resilience of biodiversity, ecosystem services and ecological infrastructure through implementation of the principles of ecological sustainability, and that there may be a contradiction because B refers to present and future generations, while point C only mentions the long-term ecological sustainability. Now, what we have found is that long-term sustainability doesn't necessarily exclude sustainability in the present as well as in the short term. So the idea was that we're happy for the bill to remain in that regard. The Wildlife Animal Protection Forum also wanted to add the word ecologically sustainable in support of the conservation and ecologically sustainable use of biodiversity services. Now, the sustainable has already been defined, so hopefully that's been covered sufficiently. Which brings me to 46. The Wildlife Animal Protection Forum of South Africa referred to Chapter 2, Clause 6, and their comments were that paragraph G should be there under Chapter 6. We currently have a G there, which says that the biological resources are used in a manner that is ecological sustainable and takes into account the well-being. Again, the whole issue there of well-being has been addressed. And they believe that municipalities and the way they should reduce urban impacts on the biodiversity in the Western Cape must be included. Now, and that municipalities have duties in terms of nature conservation as well. Now, the comment is that this bill is binding on all organs of state, including municipalities, although municipalities don't have a specific mandate for nature conservation. Then again, the same chapter, same clause, also the Wildlife Protection Forum, where it says that under that clause we should take account every organ of state, which are to take account of the benefits and intrinsic and use value of natural resources and ecosystems. They're not happy with the word take account, although the department feels that it is sufficient, it's fine. 48, also, again, they refer to the regenerative practices that should be included, and the department says no, let's not include that one, because it's only one approach in terms of the principles for ecological sustainability. The next one, under D, where they again refer to the short as well as long-term persistence. And the comment is persistence means short to long-term, but that we consider adding the word that the conservation and resilience of biodiversity for the benefit of present and future. So that under E, that we do add the words present and future. Thank you.
Sorry, sir. Can I just come in here and to note that this is an error on our matrix, because indeed clause 6 sub-clause E already is worded as we've proposed it to be amended to read. Apologies from our side. That was actually an error. Currently, that subclause does currently read, ensure that the conservation and resilience of biodiversity for the benefit of present and future generations are given priority, etc. Indeed, their proposed addition in terms of clause E was already included in the bill. Thank you.
Okay, so that should stay as it is. I think I note now I wrote the word stet next to it. Good. That brings us then to the next one, which is comment number 50 in terms of this matrix. Again, the word welfare, which they used, that takes into account the welfare and well-being. Now, welfare is a completely different term, and I think the proposal to add welfare is not supported. 51, again, there they talk of the short and long-term adverse effect, and again, it has been dealt with in terms of present and future. Then also under the principles of ecological sustainability, they make a number of proposals of what they would like, how they would like the principles to be worded. But it seems to me what we have is the principles as spelled out in the bill that we have basically covers that what they want, except that they are a little bit prescriptive in the, for example, the halting of commodification of wildlife and wilderness. Now, I think the proposal, and the department supports it, is that we stick with the principles of ecological sustainability as included in the bill currently. Good. Then the next one is number 46, also the Wildlife Animal Protection Forum. Again, to clause 6 under G, where we say ensure that indigenous biological resources are used in a manner that's ecologically sustainable. Again, they refer to the municipalities. Have I now gone backwards? Sorry, I think I have. Let me just go down. Sorry, I have. I think we're now with item number 53. My apologies. Agri Western Cape deals with the chapter 2, which deals with duties and principles, which speaks of the duty of the state. And again, it's not a specific proposal. It's imperative that the bill explicitly commits the provincial government to the principles of integrated biodiversity and resource management. And I think that's exactly what the bill tries to achieve. And it also shows the province's intent to oblige with that. Then item 54, Wildlife Animal Protection Forum of South Africa, spells out under the functions of provincial minister and the duties of the head of department. And it seems to me
Sorry,
they
Chairperson, may I interject? We may have missed one proposed amendment under 53, where we take on board a couple of the comments made by Agri Western Cape. If I can just draw us back to clause 53, please, sir.
My apologies, I see I've missed that. Please expand on that one.
Thanks, Chairperson. Indeed, we believe for the ease of reference and for completeness that indeed the bill under the duty of state, which is clause 5, should indeed refer to the principles of NEMA. And so we recommend to yourselves that we should amend clause 5 to include the following. We would add a sub-clause just in line with what Agri Western Cape have proposed, to thus apply the environmental management principles in section 2 of the National Environmental Management Act. As we've agreed before, Chair, they apply regardless of whether we put in this additional clause, but for completeness, we believe for the reader and those looking, and for the regulated community, that it's a valid inclusion and cross-reference in this particular case. And then also just to note, sir, that the definition thus in NEMA is also missing, and that we've agreed that we would include that definition under the definitions of NEMA, which we've decided would be include the National Environmental Management Act in the list contained in the definition of environmental legislation. And then just to note that we don't recommend including CARA as environmental legislation, as it falls outside of the direct executive mandate of those responsible for environmental management. But we are taking on board 2 of the other comments, or recommending that the committee takes on board 2 of the other comments. Thank you.
Good, thank you. And again, I take silence as concurrence that be included. That brings me to then 54, and I draw your attention to the last sentence there, which says urban streams and rivers should be included in all efforts of restoration, and where the province is of the opinion no distinction should be made between urban and rural ecosystems. They are all important. Then 55, which refers to chapter 3 of the bill, which deals with the functions of the provincial minister, etc. And there again, they would like for us to include in this bill that municipalities should have duties as well. And again, the comment is nature conservation is not a specific function of municipalities. Then the next one, from the also Wildlife Animal Protection Forum of South Africa, in terms of chapter 4, the powers of Cape Nature, they say the bill is not clear on priorities to recover ecosystems that have been degraded. The bill is not clear enough about exacting responsibilities and the funding, and the bill does not include appropriate measures to prevent disasters such as droughts, fires, and land water pollution and contamination. And the comment is that the definition of conservation in relation to biodiversity in statute means the protection, care, management, rehabilitation, maintenance of ecosystems, etc. And that concern, that saying that the bill is not clear enough, that concern is actually covered in the bill. Then also the proposed measures, according to the department, are a matter of strategy rather than law. Then the next one is where the Wildlife Animal Protection Forum under chapter 4 would like to include where it says under Cape Nature, promote and enable biodiversity stewardship. And they say, we note that in this section, the word biologically near sustainable has been removed. Perhaps if you would like to comment on that one.
So the comment, I believe, is bringing two different aspects together, which are don't fully, in reflection, I understand, because it refers specifically to C, promote and enable biodiversity stewardship, whereas the comment below speaks, we note specifically in the section, biologically near sustainable has been removed. And particular attention should be given to the limitations in trade. We don't really know how to respond to that, sir, because the actual comment, particular attention should be given to the limitations of trade, are not really part of the duties of Cape Nature in this context within Chapter 4.
Okay, so thank you for that. Are they referring perhaps to a previous iteration of the bill? When they say that the word biologically near sustainable has been removed?
Apologies, Chair, I would not be able to recall that immediately, but certainly insofar as the approach in terms of both the objectives and the principles of biodiversity, under Section 5 and 6, that those have always tried to make sure that we stay true to the overarching objectives of this particular piece of legislation. So I actually can't specifically reference what they may be referring to in this matter. Okay, good. Thank you very much. And then also the Wildlife Animal Protection Forum of South Africa under Chapter 4, we see there Clause 11, Powers of Cape Nature. There they believe that activities that are provided for do not have any short or long-term adverse effect. And currently it just says that those activities do not have an adverse effect. So it doesn't prescribe short or long-term, so adding short or long-term might be obsolete. It's not necessary. Then Wildlife Animal Protection Forum of South Africa, again under 4, they want to include under the thing Cape Nature may at any time in relation to any specimen or any species undertake or authorize action, including a restricted activity or restricted method, if the specimen is causing repeated damage to crops or plants on cultivated land or other property. They want us to include the word repeated damage. Would you like to comment on that one, Ms. LaRosse? Thank you, Chairperson. I believe that in this particular case, we wouldn't want to exclude any potential response from the organisation, but we haven't specified this particular issue, whether or not the outcome is to be relocated or to take any other action. And we believe that it needs to be left open, because in the context of that particular situation, one has to rely on the discretion of management. If you have an injured animal, for example, one has to take some urgent decisions, and one cannot be potentially held to a particular option where one needs to, for example, decide to relocate, or in some instances even euthanize if an animal is badly injured. We would not want to tie that particular official to something which is intractable or impractical when faced with that situation on the ground. So just to note that also in our response that the relocation is not excluded, for example, and Cape Nature is also empowered to undertake or authorize any action, including a restricted activity or restricted methods, which also would include translocation in such instance. And that to note that the IUCN updates regularly the guidelines for conservation actions or interventions that are specifically in the context of the conservation value of any such actions or intervention, and to really underscore the conservation value aspect of that. Thank you, sir.
Good, thank you very much. And then also under 59, to continue with the repeated damage, which we say no, it doesn't need to be repeated damage. They say animals should be captured, and then they want to prescribe to say and relocated where possible as first choice or killed in the interests of conservation. And while relocation is not excluded, it's not always so easy to do that. And to say that is first choice may sometimes be problematic, I presume. Then 60, and we're doing good progress, making good progress. The Wild Coast Conservation, again, gives Cape Nature the power to establish one or more advisory committees to assist it. And they feel that the composition, role and function of protected area advisory committees should be set down in the Act, and advisory committees should be defined. Now, what it says here is protected area advisory committees will be supported, and a parallel system of such advisory committees is not supported. So let's stay with that one. Then chapter 5, biodiversity spatial plan. The purpose of a biodiversity spatial plan is to set biodiversity targets, and we have that here in front of us as part 5 of chapter 5 under financial matters. Just get to biodiversity plans. Good. Chapter 5, biodiversity spatial plan. And the proposal is from Wildlife Animal Protection Forum, we require proactive restoration of degraded ecosystems. And I think they're probably referring to ecological damage, for example, more fire than others. And they are calling for the large scale and rapid restoration of ecosystems. Now, Cape Nature already has got that responsibility, but I think the important thing is that we would not want to be seen to be part of the rehabilitation, etc., of public entities. So now to say that such facilities must be used is not necessary. Again, they refer to the use of poison, to kill animals. Now again, I think by including poison, it will assist with the enforcement of cases where poison is used to kill animal. Then clause 62, comment from Drakenstein municipality. Again, the expressive response, but not necessarily one that prohibits. Sorry, I lost my story now. So, Drakenstein municipality, they refer to the biodiversity planning and monitoring, and specifically the biodiversity spatial plan. And they say local municipalities and provincial government receive many specialist studies that contain more recent and finer scale information of ecosystems, and valuable spatial information is provided in these plans, yet this information does not get captured on any system to reflect the more recent state of ecosystems. So the biodiversity spatial plan will be reviewed every 5 years, and nothing prevents a municipality from developing a downscaled plan for biodiversity. It says the comment will be further considered using the imminent update of the biodiversity spatial plan. And I think it's a valuable comment where a lot of information can be imported from the databases of municipalities and from studies which they've paid for. The next one is the issue of public participation, which is Cape Nature, after consultation with the head of department, must prepare a draft biodiversity spatial plan, and here no change is recommended. The Wild Coast Conservation said there should be a requirement for a comments and response schedule to be prepared and made available to the commenting parties. But that is just a proposal or a suggestion from their side. Then, in terms of clauses 34 to 39, again, wildlife ranching. Now, 34 to 39 deals with the biodiversity planning and monitoring, and they say that they see a conflict between this bill with the objectives of the National Draft Policy Position Paper. Now, the comment is that the Western Cape Biodiversity Bill has anticipated the policy shifts nationally and has thus taken an approach of a framework. It doesn't go into that detail, and the bill can be adapted to the promulgation of regulations. Good. Then clauses, again, 34 to 38, Sanby, which says that it supports this chapter, and they don't propose any amendments. Then the Department of Agriculture, again, is commenting on the impact of climate change, and they want the words through adaptation to be added. Again, the comment is adaptation is only one mechanism through which the resilience of ecosystems and human communities can be strengthened and should be limited. Then the City of Cape Town for clause 37.4. Clause 37.4, in terms of the City of Cape Town, is of the opinion that it does not account for listed activities that impact vegetation, not on the biodiversity spatial plan. And they say most of these plans only show the minimum set of sites required to achieve conservation targets. And the comment is that the biodiversity spatial plan is not the only trigger. It is only but one component of listing notice 3. So the clause deliberately refers to the wilder environmental legislation than to refer to individual instruments. Then 68, Wildlife Animal Protection Forum, again regarding the biodiversity spatial plan. Again, they would like to insert the word sustainable development and resource ecological use, but it's deemed not necessary to include that term. The next one is 69, Wildlife Animal Protection Forum, and it's proposed that clause to paragraph 35 be changed. 35E currently says the purpose of the biodiversity spatial plan says this is to ensure that the ecological infrastructures in the province is maintained, ecosystem fragmentation and loss are avoided, and the resilience of ecosystems and human communities to the impacts of climate change is strengthened. Okay, so that was 34E, but the department points out that conservation is already defined, and it doesn't therefore need to be added here as well. Then comment 70, again, Wildlife Animal Protection Forum. Again, they deal with the biodiversity spatial plan that must inform the provincial protected area expansion strategy. And they make the statement, we should move away from and reverse the agriculturalization of wild species. And I think we're all in agreement with that, but not for it to be included in the bill. We believe that's unnecessary. Then the next one is 71, Wildlife Animal Protection Forum. This is when people look for access to certain pieces of land, and it says access should be granted to indigenous people. Now, access to farms, I think we shouldn't legislate for that. I think we should keep it, that's my proposal, as a private matter. And that we don't give access only to certain people and turn others away. I think it can again boomerang. Which brings me to item number 72 in Wildlife Animal Protection Forum. And again, it's more of a comment that they make. Then the next one is again Ms. T. Netutando, and she refers to section 39 of the Provincial Protected Areas Expansion Strategy, and it's typical one where the Department of Water and Sanitation and the Department of Solid Waste Management meet each other, and again she says the subsection that addressed the issue of the reviews of the implementation of the Provincial Protected Area Expansion Strategy, so that when the targets have been met successfully, met the priority gap, which must be prioritized and set new provincial targets. So the 5-year review will consider the achievements and set new targets. That is typically in the nature of somebody being reappointed for another 5 years. Then again, National Biodiversity Institute, SANBI, they support clause 39. So they are happy with that one. Then SANBI, the 4th of December of this year, it says here, SANBI supports the capturing of the essential provisions of the Muslim Catchment Areas Act, but they don't propose any amendments there in terms of the bill. Again, SANBI, in clause 41, management of mountain catchment areas, they want us to change the word, whereas we currently say the provincial minister may, they want to use a stronger term and say the provincial minister must. I think let's keep the May open. It does give us the opportunity to just expand on this list later. Then there's clause 41. Clause 41, management of mountain catchment areas. Excuse, I already referred to that one, which says must. They said the provincial minister must regulate that. And we say, no, we're happy to remain with, at this point in time, with May. Then Agri Western Cape deals with sections 40 and 41, which speaks of the declaration of mountain catchment areas. It speaks to the power of provinces. It speaks to the mountain catchment areas. Again, they say they do not question the powers of the provincial minister, but then they are concerned about certain aspects. And we say this section of the bill provides for transition from the old order legislation to the new order legislation. And the recent drought has emphasized the need for both the transitional approaches and the need to strengthen management of mountain catchment areas. So we are all on the same page with the Agri Western Cape in terms of their request in that regard. There is, however, one of the proposals that the department would like, after consideration, to take on board, and that is the whole issue of landowners. When the minister wants to declare an area to be a mountain catchment area, etc., the idea is that landowners must have a reasonable opportunity to comment. Landowners must have a reasonable opportunity to comment on such intentions to declare mountain catchment areas, which I think is consistent with what we used to experience in the long past, far back. Then the next one is again, Sandby 79. It's the whole issue of a landowner, where they wanted us to take out a certain section 4 that defines a landowner, and which says that the landowner who is party to a biodiversity agreement breaches that agreement, the provincial minister may impose an administrative penalty. And then it goes on, the imposition of an administrative penalty does not affect any person's common rights. They want that to be taken out, but it's deemed not necessary to remove that piece.
Chairperson?
Yes.
May I just draw your attention to the previous comment, which is an amendment we're proposing in terms of the comment number 77.
That's the one from Agri Western Cape?
That's correct, sir.
Thank you. I missed that proposed amendment. Please go ahead. Item 17. Item
77.
Sorry.
Item 77, and we wanting to take on board the specific, actually to remain consistent with other sections of the bill, and to bring the section on mountain catchment areas to be consistent with that, is ultimately to agree to add, as is requested by Agri Western Cape, to amend clause 40, sub-clause 5, to read, before issuing a notice contemplated in subsection 1A, 3 or 4, the provincial minister must, in the prescribed manner, notify the landowners concerned of the intended notice and the consequences of the notice, and afford them reasonable opportunity to comment. So it's with the addition of the underlined words, and we would like to recommend that to the committee to take on board this particular comment. Thank you, sir.
Thank you very much for pointing that out. Good. Thank you very much. I was under the impression that we indicate that we were happy with that to be added, as it obviously gives people a right to just administrative action. Good. Then 78, we've dealt with that one. No, not yet. Clauses 41 and 47. Again, there's a feeling that 47, the protection of ecosystems, ecological infrastructure and species, that 47 may be a bit too harsh. As they say, the bill create the misleading impression that the declaration of mountain catchment areas, MCAs, or listing of ecosystems and ecological infrastructure could automatically result in the control, restriction and prohibition of existing lawful farming activities. This is now the fear that Agri Western Cape has expressed. And then also under that we get prohibition or circumscribing existing and otherwise lawful agricultural land use, or preemptory restricting agricultural expansion into undeveloped areas where, all things being equal, such expansion would be normally subject to prescribed environmental assessment processes and their procedural checks and balances. And Agri Western Cape say we propose that this be addressed by the addition of text to ensure that the provincial minister may only impose justifiable and reasonable restrictions in the rights of landowners to use their land. Now, the comment from the department is that the declarations are not arbitrary or wide, and that there is enough guidance also of the direct consultation with landowners that is already included under section 45, and that any decision taken by the provincial minister must be reasonable and rational, and the principles of administrative justice apply. So hopefully that gives enough protection there already to the farmers that are concerned about this. Then again, we're busy with item 79, SANBI, the National Biodiversity Institute, Biodiversity Stewardship, and they want us to remove 2 paragraphs under clause 42, clause 42, under the number 4 says, if a landowner who is party to a biodiversity agreement, actually to a biodiversity stewardship agreement, breaches that agreement, the provincial minister may impose an administrative penalty, and the imposition of an administrative penalty as contemplated in subsection 4 does not affect any person's common rights. SANBI wants that to be removed. Now, the department points out that this is a discretionary provision. So they believe it could remain. And then item 80, again, the biodiversity stewardship under clause 42, where they say they support the merger as well of clause 42 and 43. 42 deals with the declaration of private nature reserves, and 43 speaks to biodiversity stewardship. The department has just said that they note this proposal of this merger. Obviously, it's not for us to merge.
Sorry, sir. It refers to a previous draft where we have merged those two. So they're supporting the merger as reflected now in the new bill.
Okay, so they're happy. It seems that as if they should be happy. And the same with BirdLife South Africa. So we say that BirdLife South Africa is in support of all the stewardship programs. And this, we say, yes, we as a province also support that. Then there is an interesting comment from your side, Ms. LaRosse, where BirdLife South Africa reads something in the legislation which you believe is not there. Would you like to expand on that one?
Thank you, Chair. I think it's in relation to how we move forward with the various emerging approaches to biodiversity stewardship in the country. And as noted earlier, we are piloting some new approaches, actually specifically within the province. You may have heard that we've mentioned this word, other effective conservation measures. Well, those are intended for inclusion in any system moving forward. And also, I think that the insistence that a piece of legislation should now be aligned to an emerging guideline or a guideline is not practical, because guidelines may be subject to change. I think also specifically in terms of the principles, it's actually a misreading of the intention of that section, partly to accommodate these new emerging approaches rather than exclude them. So I think it is just a slightly misunderstanding of the intention, and that, you know, the legislation is obviously the higher order framework with which one works, and indeed you try and implement that legislation with emerging guidelines and good practice. And as I've mentioned, the other effective area-based conservation mechanisms, etc., that are coming to the fore, the intention is definitely to incorporate that. So we've noted that the guideline is just that, a guideline, and also needs to be adapted for the new mechanisms emerging in the landscape. And also that we would include all recognized modes of stewardship moving forward, including OECMs, that we would like to see move forward in terms of the implementation of the protected areas expansion strategy for the province. Thank you, sir.
Good, thank you very much for that. So, as you've said, this whole issue of stewardship, and we've got this expansion strategy. So you believe that BirdLife South Africa is reading something into this legislation that is not there, and that they are unnecessarily concerned about our system of stewardship.
Yes, so we've designed this to be as open and forward-looking and flexible as possible in order to embrace these new developing processes. And even in such, we wouldn't propose developing necessarily a Western Cape guideline. We would rather work together with our national colleagues in implementing the national guideline in how we implement the protected areas expansion strategy. So it's definitely written in terms of embracing new and innovative approaches rather than writing them out in legislation. Thank you, sir.
Good, thank you. Then again, 82, Agri Western Cape has got a proposal, or they say that the bill must make explicit provision for devolved and participatory ecosystem governance. So this seems to be at a local level that they want that to be addressed. And they also propose an amendment that a conservation committee must include certain functions, and then they want various conservation committees, as I've said, at ground level. And the comment from the department is that a conservation committee is already provided for in the legislation, and it is also one of the committees on the Cape Nature Board. And that we can't have conservation committees working in isolation of one another, and not. We should combine or merge the work that's been done then by the Conservation Committee, it seems. Then on page 35, again, it is not seen necessary or desirable to legislate for certain, as I've said, these local conservation committees. And obviously the detailed presentation from or comment from the Western Cape Agri Western Cape is therefore not accepted. Then the next one that we get to is 83, again the National Biodiversity Institute, SANBI, and they say they're in support of clause 47, and we appreciate that. And then also they make a proposal that clause 47.5 makes mention of being an offence to not comply with a notice on subsection 1. And the department says yes. You propose that we delete clause 47.5. Is that correct?
Yes, Chairperson, that is correct. Ultimately, it is going to be addressed under section 72 and needn't be duplicated in this section. It was possibly a drafting error that the subclause 5 remained under the section rather than being consolidated under the compliance and enforcement section. Thank you, sir.
Okay. Good, thank you. And we therefore appreciate the input from SANBI. Then Agri Western Cape, in terms of clause 47, are concerned that it may give too wide powers to restrict or to prohibit activities. And they say that notice is issued in terms of the management of conservation areas, mountain catchment areas and ecosystems in need of protection of the bill create the misleading impression that the declaration of mountain catchment areas or the listing of ecosystems and ecological infrastructure in need of protection could automatically result in the control, restriction or prohibition of existing lawful farming activities by either prohibiting or circumscribing existing otherwise lawful agricultural land use. Now, the comment that you've put forward as representatives of the department is that any decision taken by the provincial minister must be reasonable and rational, and the principles of administrative justice should apply. Now, Agri Western Cape wanted the addition of text to ensure that the provincial minister may only impose justifiable and reasonable restrictions, and it seems to me you say we're of the opinion that that is already covered in terms of general law. Then the next one is the Wildlife Protection Forum. That is now item 86, and we are making good progress. Wildlife Animal Protection Forum of South Africa in terms of Chapter 7, Clause 47, which deals with ecosystems or ecological infrastructure in need of special protection. They are again referring to the rewilding areas, restoring habitats, and what they call regenerating soil and water courses. reversing fragmentation, etc. And the department is of the opinion that these powers that the Wildlife Animal Protection Forum would like to see is already accommodated in the powers of Cape Nature. Good. So let's go on. 87, Sanby speaks of biodiversity offsets and other mitigation measures, which is dealt with in clause 48. Now, they have an amendment that they propose in that clause 48, which they say the provincial minister may prescribe requirements and publish guidelines for biodiversity offsets or other mitigation measures in the province in line with national guidelines and policy in order to attain the biodiversity targets. And the comment is that any regulations in terms of biodiversity offsets will in any case need to be aligned with national policy, and the change is therefore not necessary, and the proposed amendment is not supported. 88, comment by the City of Cape Town on clause 48. 48 again, the one of biodiversity offsets. City of Cape Town say it should have a sub-clause explaining alignment with the draft national biodiversity offset guidelines. And they ask the question which takes precedence if the prescribed requirements conflict. And the comment is any regulations published on biodiversity offsets will need to be aligned with national policy, and therefore no change is necessary. Comment 89 by Ms. Netunonda. Provinces must be recommended for leading the pack on the issues of biospheres reserves and the funding of biospheres reserves. It's just a comment that she submitted, or a wish. Then the next one is again Mr. Errol Finkelstein and the Western Cape Biospheres Reserves non-profit organization. And Mr. Finkelstein has commented quite widely on clause 43. Now, just to take you back to clause 43, clause 43 deals with the application for a UNESCO designation as a biosphere reserve. And he is concerned that the biosphere reserve section in the bill ignores the national framework for the creation of bodies of this type. And I refer to the non-profit company, which is the primary vehicle for new bodies for public good, in which biosphere reserve is certainly one. So in that area, there's also the idea of an interim. Accordingly, the term interim committee, which appears to be carried forward from the pre-NPC era, is not only inappropriate but confusing. And he says the typical process to create a new biosphere reserve in the Western Cape is to form an interest group. Now, the comment is a non-profit company is only one legal form that may be adopted for the biosphere reserve, and therefore it is available to non-profit organizations to buy such land and then have it registered as the biosphere reserve. But then the department also points out that there may be a risk prior to the acceptance in principle of the establishment of the biosphere reserve, which is a decision of the provincial minister in his or her recommendation to the national minister. And also Mr. Finkelstein says the initial board of directors of the non-profit company will in reality submit the application to UNESCO via the Western Cape. But the department says they don't believe that that should lead to any changes in the proposed bill. Also under 91, the the next one, comment 91. In chapter 8, wildlife animal protection, says they have broader questions when risk assessments are used. And obviously that is not a proposal to change the diversity bill, so it's just noted. The same with the next one. They say transparency is currently a major issue, and before granting an application for authorization, the CEO may require the applicant to furnish the independent risk assessment or expert evidence. Now again, it's just for noting. Again, in chapter 9, when it comes to compliance and enforcement, again, they're asking questions in line with the objectives and vision of this bill. What is the best strategy and policy when wild animals are found injured? Who has the duty and capacity to treat the animals? Now, again, these are just questions that they ask. And they actually already have enforcement provisions, and it does provide for a range of measures or treatment of seized or forfeited specimens, which can include, for example, to euthanize specimens, etc., or relocate, etc. So it is actually provided for in the bill. 94, again, Wildlife Animal Protection Forum, in terms of Chapter 9, Clause 67. They say we need specific local policies for when animals are found injured or are confiscated. Now again, policies, regulations, I believe is not something that we should include in the bill. And please note that such policies may be needed, Ms. LaRose, but policies not part of the legislation itself. Then in terms of I think this one of Cape Town deals with the enforcement and inspection and so on, clause 63, the inspections, and that the rights or the rights that are given to nature conservation officers under 63(1) and 2, that should also apply to nature conservation rangers. And the feeling was that this should be reserved for nature conservation officers while under the supervision of the CEO. A ranger is somebody in the employ of a municipality and obviously are not under the employment supervision of the CEO. Obviously, if municipalities have nature areas, they can have their own officers and or rangers in that case, and they can decide on what powers those rangers should be allocated. Then 96, again, City of Cape Town, clause 65. Now, clause 65, again, with the power to stop, enter, and search vehicles, etc. They would like this to apply also to municipal nature conservation rangers. Again, the legislation that we're dealing with is only, I almost want to say, for the province. We are not including municipal officials in that as well. Then comment 97, Sanby. Again, they fully support the incorporation of administrative penalties in the draft bill. And perhaps, Mr. LaRosse, you will know that, the issue of spot fines were raised the previous time. This time, administrative penalties. Again, Wildlife Animal Protection Forum, they are also in support, they say, of chapters 10 and 11 under offences and penalties. So I think it's good to see that there is support for that. Then under chapter 10, they also the Wildlife Animal Protection Forum also want to include traps in the items to remove. For example, where clause 72(1) says when somebody conceals, removes from any premises, destroys or disposes of anything that could serve as evidence to prevent that, and they want traps to be included as an item to remove that could probably also serve as evidence. And the comment is that traps are included under the term implement that is being used there in 72(1)(I). Let me just see that for myself, 1(I). When it says that you can remove any specimen, book, register, document, electronic record, vehicle, machinery, implement. An implement could then be that a trap as well. Now we come to number 100. Again, Wildlife Animal Protection Forum. And there they want a number of things. To include rescue and rehabilitation facilities definitions, to include reputable sanctuaries as an option where release is not possible, and they want a better definition of what appropriate manner is. It should be euthanasia from a vet. And again, the comment is that these mechanisms will be elaborated in regulations that will align to IUCN guidelines or best practice. So not necessarily included in this legislation. Then 101, clause 84, under 7, 84, 7 is their numbering, recommended procedures for intergovernmental and public consultation. Now, Agri Western Cape is of the opinion that there should be an amendment. Section 84 of the bill, when it comes to consultation, should be amended, and they want under B, where it currently says it's a new B that they're proposing, consult with all organs of state, whose areas of responsibility may be affected by the proposed regulations or notice. And it seems to me there's a amendment that you may support, Ms. LaRosse, in this regard.
Yes, indeed, sir. We recommend to the committee that we add subclause B under 84(1). Thank you.
Which will then mean that the current B and C be renumbered?
Yes, sir. Consequential renumbering we would need to take care of as well. Thank you.
Good, and I think that is just something which we will then, when we deal tomorrow with the agreed to amendments, we will just have to look at the renumbering as an amendment as well. Good. Then the next one, coming back to 102, the transitional provisions. So SANBI just expressed its support, so there's no amendment proposed there. 103, Wildlife Animal Protection Forum. Again, they point out that transparency and communication between members of the public and Cape Nature are matters of concern. They do not necessarily propose an amendment. So let's just take note of that concern expressed by Wildlife Animal Protection Forum. Then in terms of chapters 11 and 12 of the under the general and transitional provisions. It's clause 88. They propose that provisions to increase transparency and accountability are to be included. Now, no change is recommended because appropriate mechanisms for administrative justice are already included according to the department. So let's stay with that one. Then 105, again, it's comments on the bill, and they say it's appreciated that the bill consolidates various laws, but then also our view is that the province should only preferably legislate where there's a gap in the current national legislation. Now, this bill is intended to address critical gaps, and furthermore, they say the bill should be read in the context of processes that are underway for the amendment of NEMBA. Now, I think the department's comments say that where protection members are not adequately provided for in NEMBA, such measures will have been retained in the drafting of the bill. Indeed, the bill proposes to address gaps or to provide for relevant contextual needs of our local ecosystems. Good. And they ask of us as committee to consider the above mentioned comments that they've made. Then also to jump back to chapter 7 and 8, they believe that some of the chapters should be switched around. Now, the comment is that the arrangement around the very functionality is not required, as the sequence does make sense in terms of the framework legislation. Also, the definition of authorization. Now, the definition of authorization means any registration certificate, license, permit, or other written permission. So that is covered in the current piece of or the bill that we have, in the current definitions that we have. Then again, there's a question whether biodiversity offset should not be narrowed down to refer only to those agreements that are authorized by a competent authority. And the response is that the broader definition is preferable. Then again, critically endangered species. Now, the critically endangered species, they would like us to amend the definition, and the department's response is that definition is already determined by the IUCN as critically endangered species and includes species listed by the provincial minister. So the minister can already include certain species. Good. Then we're going on to 110, definition of development. It says the definition is more the planning process than the actual development, and the proposal was to consider replacing process with something else, as the process itself is not what affects biodiversity, but the outcome of the process is what affects biodiversity. Again, it is noted, but the intention is definitely to include the processes that change the use or function of a place, which includes, by definition, planning processes. The same an input regarding the definition of environmental legislation. Now, I think we've already now included NEMA as one of the pieces of environmental legislation, so this comment has been taken on board. Then again, export to attempt, and that one was then accepted. that export doesn't only mean the physical export, but also the attempted transfer that has been then with, again, the definition of hunt. And the question is the intention that the shooting of an animal with a dart for the purpose of capturing the animal, will that be regarded as hunting? If so, would a person need a permit to hunt or capture? Now, hunt does include to shoot at or poison the animal by any means whatsoever for the purpose of killing, injuring, or capturing, or attempting to kill, injure, or capture it. So my impression is that is already dealt with or included. Then there's also raised the definition of landowner. And again, our definition does include not only landowner in the traditional sense, but also somebody who exercises general control over the land. So no change or amendment is seen to be required there. Again, the whole issue of well-being, we've dealt with that. Therefore, well-being definition has been amended, or there's a proposed amendment to that. And then under number 116, the ecologically sustainability, and again, that proposal has been taken on board to amend clause 5 to include the words "and apply the environmental management principles in section 2 of the National Environmental Management Act." So that one is taken on board. Then also by the Department of Forestries and sorry, just help me with the DFFE.
Department of Forestry, Fisheries and the Environment.
Good, thank you very much. Again, they proposed certain aspects there. They say there's no function relating to the implementation of the provisions of this Act or its subordinate legislation under the functions of Cape Nature. Now, the response by the department is that Cape Nature's functions and powers are set out, but there are also other parties identified with functions and powers, including the provincial minister, the CEO, the board, and the HOD. Further comment is that the World Heritage Sites mandate is a national competency, and it would only be appropriate for Cape Nature to report if they've been appointed as the management authority. And the response is Cape Nature is an appointed management authority of World Heritage Sites in the Western Cape. Then further comment was enforcement responses to non-compliance may be broader than just the institution of a criminal investigation. And the proposal was reword detect non-compliances and deficiencies and institute appropriate enforcement actions. And our attention is drawn to the section on compliance and enforcement, and which says that in areas under its control can take measures that are necessary or desirable for the conservation of biodiversity and the management of adverse effects thereon. Then also from our national department, there was a comment on the powers of Cape Nature. They say if Cape Nature undertakes the restricted activity themselves, they may well trigger permits in terms of national legislation. And obviously the view there is that Cape Nature cannot decide on itself. And the comment is that this is true, this is agreed to, but this is not excluded by clause 11.4. And then clause 37, the use and application of the biodiversity spatial plan, and the comment is that no provision is made that such a plan is developed in terms of the Act, and that it must be consistent with the plan developed by the Minister in terms of NEMBA. Now, the biodiversity spatial plan may be more restrictive than the national biodiversity plan contemplated in amendments to NEMBA, but that also does not yet exist. So I think, in a sense, the department wanted us to hold back, but we cannot hold back for something which, we don't know when it's going to be implemented or to be adopted. Good. In clause 120, again, systematic biodiversity plans. And the National Department refers to the fact that NEMBA makes provision for the adoption of bioregional plans for bioregions in South Africa. And it is also in their bill proposed that the Minister or an MEC may adopt a spatial biodiversity plan for a municipality or a province. And the comment is there that having regard to the substantive duplication of the provisions of NEMBA and the NEM bill regarding systematic biodiversity planning, but also taking into consideration the Western Cape Province's intention to better ensure that the province's systematic biodiversity plan is taken into account in planning and environmental decision-making in the province, we propose that the bill is amended by deleting the provisions relating to the preparation of the biodiversity spatial plans, but retaining the provisions regarding the consequences of the adoption of a systematic biodiversity plan for the province. The term biodiversity spatial plan can be replaced with bioregional plan and later spatial biodiversity plan. And the comment is retaining one element which does not refer to the proposed regulatory framework in the Western Cape doesn't make sense in terms of coherence within the bill. Ms. LaRosse, would you like to expand on that one?
Thanks, Chairperson. I believe that you've already alluded to the approach here is that the mechanisms that are still to be put forward under the new NEMBA are not yet in place, and we need to tighten up the articulation of proactive biodiversity spatial planning, which is embodied in the BSP, and to move forward with that as soon as possible. And it does not conflict in any way with what the national frameworks are in terms of the actual national biodiversity assessment, or even the definition, for example, of the status of certain ecosystems. However, we may wish within the Western Cape to take into account other aspects of contextually driven considerations, and hence it's important for us to move forward in this way. We cannot anticipate the long process or the conclusion of the long process that is still coming, and in any case, if we were required to make amendments in the future, we could also do such. But to wait and have nothing in the meantime, I believe is not the responsible thing to do, specifically with the effort that is proposed in linking the BSP, for example, to provisions within the Municipal Systems Act and within SPLUMA and LUPA. Thanks very much, Chair.
Good, thank you very much. And the same applies then also to paragraphs 122, 123, or comments 122, 123, where again the National Department says that, we bring it to the Standing Committee's attention that it's the Department's intention to insert a provision requiring the Minister to adopt a National Protected Areas Expansion Strategy. And the same, I think, applies that, as you've just said, in the absence of those amendments that they believe they would like to bring, that we cannot just sit on our hands, we must move forward. And obviously, even they, it seems to me, recognize it will be a while before any amendments are made to NEMPA. So I think we just note of their views in this regard. So then there was another proposal by the National Department when it comes to the declaration of mountain catchment areas, and they say it may require more than a notification if done on privately owned land. It would require landowner consent. Right to procedural fairness as contained in PAIA is applicable. And it seems to me, Ms. LaRosse, you say you agree with that, and therefore you would like to amend clause 45. Would you like to just fill us in on that one?
Yes, Chairperson, this is consistent with a comment we've also received earlier in relation to the same section from Agri-Western Cape, and we support that we add the additional clause to that particular section, 40 subsection 5, before issuing a notice contemplated in subsection 1A, 3 or 4, the Provincial Minister must, in the prescribed manner, notify landowners concerned of the intended notice and the consequence of the notice, and afford them reasonable opportunity to comment. And so we would recommend, Chair, that the Standing Committee also proposes such amendment. Thank you.
And then therefore add the words and afford them reasonable opportunity to comment. Good. Then the next one also deals with the mountain catchment areas. And the comment there is that, you know, we take note of it, and mountain catchment areas are only recognized as a protected area if they were declared prior to NEMPA coming into effect. So new areas would not be recognized, and it seems to me that those new areas should obviously also be recognized. And the explanation is the purpose of this section is to ensure that the status of mountain catchment areas is maintained while other mechanisms for securing strategic water source areas are concluded and or portions of existing mountain catchment areas are regularized into protected areas such as nature reserves or protected environments as relevant and desirable. Good. Please interrupt me if you want to, Ms. LaRosse. Then also the next one also deals with the mountain catchment areas, and they say there are no explicit requirements for the declaration of a mountain catchment area in the Mountain Catchment Area Act, and an MEC may issue directives, and compensation is payable to a landowner affected by directives under circumstances. And I think what we've said is that we note, and again, the same problem, that any new areas declared under the bill would not be recognized under Section 12 of NEMPA, and that we just want to protect those areas, or protect the status of those areas for the time being. Good. Which brings us to comment 127. Again, it is just for us to note quite an extensive explanation on the existing legislation and how the National Department is seeing that. They do not propose any changes. They just say that some of the bill's provisions may well have to be reviewed once the national legislation has come into effect. 128, the same issue, where they actually want to to say that their bill will be similar to ours, in that the minister is given a much wider discretion. And for the meantime, we in any case believe it's desirable for the MEC to be able to provide for such a listing. Then 129, biodiversity offsets. Again, they give us their understanding of this biodiversity offset concept, and we just agree with them in that regard. The next one also, the National Department says the bill provides that we may publish guidelines on biodiversity offsets, and that they are currently also working on a biodiversity offset guideline, which is good. And it's good for us to know and for you as officials to know, so that hopefully we can align our thinking in that regard. They will probably also give us an opportunity to comment on theirs once they publish that in draft format. So there is a concern in terms of their comment, numbered 131, that in the event that species is already regulated by TOPS under NEMBA, would it not be possible for the person to obtain an integrated permit so that authorization processes are not duplicated? Perhaps this bill needs to be specific in the event that there is such an overlap. And the comment from our department is that in this instance, no overlap with TOPS is proposed or provided for. Then, in terms of the conservation of threatened and protected species, again, they are concerned about some of the overlap, and that there would be two parallel regulatory systems for the same species. And obviously, they say such a situation should be avoided. And what our bill says is that the discretionary clause allows for the minister to list species not adequately protected under TOPS. So there may be provincial species, which we believe is under threat, and that we as a province, especially within this province, may want to protect and therefore list. Then again, the clause 49, where it says NEMBA does not authorize an MEC to adopt a provincial list of invasive species. However, parts of the list of invasive species can be made applicable in only certain provinces or areas. Now, perhaps, Ms. LaRoche, you can just help us when they say there is scope for overlap. The MEC may identify species that are already on the national TOPS or invasive species list, which would result in a person engaging in certain activities having to consider two separate regulatory regimes for those activities. You say there will be provision for integrated permits if needed. Perhaps if you could just fill us in on that comment from the department.
Thanks, Chairperson. As indicated under one of the previous comments, which was at comment number 131, which we speak to integrated permits being provided under clause 54. To note here, though, that in this particular instance, it's seen as desirable that for the province to publish a list to address the gaps in the threatened species listing, as we've explained above. And perhaps if I can just note here, for example, the recent cases of succulent poaching, we would have really been in a difficult position in order to be able to enforce anything in relation to that, due to these species, not many of them not being included under TOPS, nor they being affected by activities which would be regulated thereunder. So in that instance, we wouldn't really have been able to take the action we have. However, under the ordinance, these were listed under the classification system. So there are clear gaps which we would like to address, which we need to address, which in fact, if we don't address, would be not doing our job ultimately. However, the way in which we work, which is really closely with the National Department, would be to ensure that any unnecessary administrative burden is removed from the regulated community by enabling such integrated permits if needed. And then further, in terms of, I'm not sure if you were also requesting comment on comment 134 in terms of the management of alien and extralimital and invasive species. We believe that the extralimital species are a really important aspect to regulate in terms of our unique Western Cape ecosystems, and that it's desirable and necessary to specify that subset of species. Thank you, sir.
Good, thank you very much. And if I can take you then to comment 135, where the National Department says that we need to include a ground for refusal if an application is inconsistent with any restricted activity that is prohibited in terms of the Biodiversity Act. And it seems to me that the proposal is that we then indeed include a reference to the Biodiversity Act. Am I correct?
Yes, sir, we need to include such, and the proposal there is to insert subclause C, so that 51.3 would then read, the Chief Executive Officer must refuse an application if it is inconsistent with A, principles of ecological sustainability contemplated in Section 6, or any other provision of this Act, B, any relevant strategies or plans adopted or approved in terms of this Act, and then the insertion of C, Biodiversity Act, which is defined, and then we would have that consequential amendment of C to D, subject to Section 231 of the Constitution, any applicable international agreement. So we would like to take that on board and recommend the committee, recommend that to the committee. Thank you, Chair.
Good, thank you very much. Can I then just present to you the last comment for today, because I see it has just turned 5 o'clock. Comment numbered 136, which speak of the word granting in the proposed that is in front of us. It says before granting an application for authorization, and I think in the earlier meeting we've already said before making a decision on an application. Perhaps you could just fill us in, and then that is still the latest view of the department, that we changed before granting an application, just say before making a decision on an application for authorization.
Yes, so we would recommend that change to the committee in order that it accommodates an approval or a negative decision as the commentator has indicated. Thanks, Chair.
Good, and thank you very much for that. Honourable members, our time has run out. Thank you very much for your patience. It's been a very intensive one, and many of us, for those officials that didn't follow us this morning, we already had a lengthy and intense meeting this morning on the annual plan of the Department of Agriculture and CASIDRA. So my apologies if I faltered from time to time this afternoon, but thank you very much. Honourable members, officials, we are meeting again tomorrow morning at 9 o'clock. Again, it's an online meeting. And Ms. Niekerk, perhaps before I conclude this meeting, is there anything else that you would like to draw our attention to at this point in time?
Yes, thank you, Chairperson. Chairperson, just gathering now from the meeting, the committee now, am I correct in saying that the committee is in agreement satisfied with the department's responses to the stakeholder input. And the committee is also in agreement with the proposed amendments to the specific clauses as per the department.
Yeah, please note we've only considered the comments up to 136. Obviously, there are still some further comments to consider, including, I believe, comments that again led to certain proposed amendments.
All right.
So tomorrow morning we will reconvene and we will start with 136. Sorry, probably then 137. But in general, I think you're right. What I've said initially, informally, I think we must still get buy-in from caucuses, etc. That this committee is in agreement and recommend a number of amendments to the bill that has been served, or that is currently serving in front of us.
All right, all right. So in the interim, Chairperson, just to make things easier for tomorrow, what we could then do is just put a list of agreements that were agreed to in this committee together, so that the committee can then have a look at those the list of amendments tomorrow morning.
That would be fantastic, and I really would appreciate it. I do know it's been a long day for you and many others as well. But it will certainly, I think, help us to focus tomorrow morning just on those amendments to the bill as originally submitted to us. Would you call that then the A version?
That is correct, Chairperson. It would be the proposed amendments, the A list. But just important to note that amendments, the list of amendments, would not have been certified by the legal advisor as yet.
Which is still an outstanding issue. We must still give Advocate Marstorp an opportunity to go through it as well.
Correct. I think it's too short a time now between now and tomorrow morning for him to do that.
Good. Thank you very much. Thank you for drawing our attention to that as well. Thank you for undertaking that task as well. And then with that, I would like to say to the honourable members, thank you very much for a long and hard day. And then also to our officials, thank you very much for assisting us, explaining to us, giving us the rationale behind some of the clauses, etc. It's really appreciated, and I look forward to welcoming you all tomorrow morning again at 9 o'clock when this meeting will continue. Thank you so much.
Thank you, Chair.
Thanks,
Thank you,
bye.
members.
Thank you,
Goodbye.
Chairperson. Bye-bye.